Invito ora Laura, dottora Laura Raquel Bordón de
First of
Fernández.
all, I'd like to invite Dr. Laura Raquel Bordon, an advisory to the legal department of the Ministry of Public Health and Welfare of Paraguay. Before holding this position, she was the legal counsel of the National Department of Health Surveillance. Ms. Bordon has a plane to catch, so when the time for the discussion comes, she will have to leave before that because she has a plane to catch. Good afternoon, everybody. Just like Monica said, the last table, but not the least important panel, without further ado, I will invite the experts on this subject matter. I'd like to invite Mr. Ken Shadlen, Mr. Reinaldo Guimaraes, and Mr. Reinaldo Guimaraes and Mr. Antonio Carlos Becerra.
Iniciamos la primera exposición.
So we will start with the first presentation by Ken Shadlen. He's a politologist. He works at the Department of International Relationships of the London School of Economics. He works in international politics, comparative economy. His main areas of research include IP policies, the global and transnational ones, as well as trade and economic integration policies. He has even worked in the area of trade agreements, North-South trade agreements. He is studying the consequences of the new global IP regime and the ways through which the new standards and global rules on IP are taken to the countries and impact each country. So, Mr. Shadlen, please.
¿Está prendido? Bueno, voy a hablar en español. Espero que me entiendan.
Speaking in Spanish, I hope you understand me. As I'm Argentina, I feel more at ease speaking Spanish. First of all, just like all the other speakers, I'd like to thank the organizers, the technicians, the people in charge of logistics for inviting me. These have been 2 very nice days and interesting days. I've learned a lot from the excellent presentations we had yesterday and this morning. And I have to say, being fully honest, that it's an honor for me to share this panel with these 2 gentlemen who have played an important role in the case of Brazil. I'm going to talk about, well, the slides are in English. I'm going to talk about politics and practice in the case of TRIPS implementation.
Okay. Para empezar, el tema de implementación.
The implementation is key. Everything is related to implementation. All the things we care about are related to implementation. The questions, the issues, the answers are related to implementation. What do countries do within their borders? How do they take the new global standards and translate them into domestic standards and practices? As I have it on the slides, all the effects we see daily are the result of the way the international rules and standards are implemented in each country. And what strikes me, I pay attention not only to written laws and codes, but also laws in practice. The rates of patenting, the coverage, the number of medicines and agents that are patented in the countries, the conditions for market entry, the prices, everything is a function of implementation, not only of IP. I have 2 research projects on implementation. I'll try to cover both of them in 20 minutes. I think I can do it. Otherwise, well, sorry in advance. One of them is a comparative analysis of the patent systems in Latin America. I analyzed the cases of Argentina, Brazil, and Mexico, the largest economies in the region, and from the 80s until nowadays. And the outcomes I study are policies, public policies, which are the new patent systems like for the pharmaceutical arena. The second one is an empirical analysis, and it talks about ways of approaching the issue of secondary patents, patents on new molecules, polymorphs, new formulations, new methods, or new ways of using a molecule which is already known. And in this case, I analyzed 10 countries all over the world from Asia, Africa, Latin America, plus the trilateral patent offices. Here I look at Section 3D in India, anuencia previa in Brazil, or prior consent in Brazil, examination guidelines, pre-grant opposition, etc. In this project, the goal is not to analyze the public policies per se, but their results, their outcomes, which are the outcomes of the patent analysis systems, examination systems. Before going into my two projects, I would like to say something very brief. All the information on this slide is crystal clear and obvious, but it's worth highlighting as we have it in italics. It's not always easy to observe the effects of poor access or limited access. We have talked a lot about impact analysis, what the impact will be like, and it's tough to know. On one hand, because the lack of access does not necessarily mean death. My question is, where are the corpses? So if I don't receive the drugs, am I going to die? So we could have a body count, counting the corpses, but not all. But this doesn't apply to all areas. In the case of AIDS, well, this is the flagship case, because if patients are not treated with antiretrovirals, they will die. But in some other cases, if you don't have access to a patented drug, you use another agent, another treatment of lower quality, but you are still alive, suffering pain. You have to switch jobs. You have to spend a lot of money traveling to the hospital 5 times a week. There are many difficulties and problems which are real, and they are related to lack of access, but they are very difficult. It's very difficult to measure or quantify them. Besides, if you have access, you may have other problems which are not as visible. If you pay more to give treatment to AIDS patients, you have less money to treat other diseases or other patients. I think that the third bullet point talks about differential pricings. If pharmaceutical companies are going to drop the price, which the price would be low if there were generics, of course, this would mean a price reduction. Or if you pay more, well, you don't have so much money left to pay for physicians, equipment, etc. Many of the things we have been saying in these days have a temporal attribute. It goes between now and the future. If the patent office grants a patent on a new formulation of an agent, of medication, this may extend the exclusivity period. That's why we don't like it. But it's not going to extend the exclusivity period until the patent on the molecule, on the compound, expires. That is, we are making decisions today which will have consequences in the future. It's very tough to know what the consequences will be in the future. As I said earlier, or at the very beginning, I think that all these points are clear, but we very often forget about them, and they have effects on policies and politics, because as many people have said, intellectual property policies are related to trade policies. You don't negotiate in a silo. And when you are talking to exporters, ministries of trade, they give you figures of the benefits they get with a better access to the markets. Maybe the figures are not the right one, but they have a methodology to calculate that if we sign this agreement, we'll have this import duty on this good, and we will be able to export for this amount of dollars every year. They may quote figures. For us, it's very difficult to give figures about the effects. So it's difficult to count the bodies, the corpses. Sorry for taking so long on that slide. Let's talk about these three countries. There are two waves, two stages of stage. In the 90s, countries were introducing new patent systems for pharmaceutical products. The key issues were when to do this, the issue of transitions, and how to do it. Granting retroactivity or not. That is, what do we do with the patents and applications that were submitted before 1995? Do we forget about them, or do we give them some kind of protection? The discussion in the 90s was not whether to set up or how to define the new global rules, but not whether to have them, but how to set up new rules. That's why we have different degrees of over-compliance.
How far beyond the plus do you go?
The second wave is the wave we had in the 21st century, where we are facing the problems created by the new patent systems introduced in the past. New patent systems, criteria on exclusivity, market entry barriers. Just like in all discussions get more focused as time goes by. What were we discussing in the 80s? Well, whether developing countries should have pharmaceutical patents. That was the discussion in the 80s. Which was the discussion in the 90s? When and how should we introduce such patents? What are we discussing today? How do we meet, or how do we solve the problems we have because of the fact that we have patents? So we are narrowing our focus as time goes by. There is a lot of information on this slide. Let's look at the dark lines. Two ways of thinking. When patents means when patents were first granted, and pipeline is what I meant by what do we do with those products that were already in the market before 1995. All the products coming in 1995 or later are treated immediately or go to a mailbox. But those that came in before 1995, well, what do we do? So here we have the TRIPS requirements, the USDR, STR requirements, and Mexico, Argentina, and Brazil requirements. Mexico introduced a system which I called hyper-maximalist. They did everything very early, 1991, and with a pipeline. Argentina was more minimalist. Until the end of the 2000s, no pipeline. That is, the application requests coming from 1995 onwards went into the mailbox. We analyzed them starting on October 2000, but those that were there before 1995 will never get a patent in Argentina. Brazil, maximalist, not as much as Mexico, but maximalist regimes starting in May 1997 and looking backwards with retroactivity. Let's talk about the effects. There are several ways of looking at this. I have this. I looked at all the new molecules or products or medications approved by the FDA between 1996 and 2004. I looked at all the patents related to these medications. In the Orange Book, I found 159 drugs with 626 patents. After that, I went to have a look at the applications in the three countries, but not all applications are present in each of the countries. And in each country I tried to find out what was happening.
260 patents in Mexico, very few from the pipelines because they were granted after 91. 94 drugs were patented in Mexico. In Argentina, 81 patents granted. Out of 600 and something, 81 have a patent here. 29% of medicines have a patent. Brazil has many patents, and most of them are from the pipeline. The important thing is that 85 of these drugs with a patent are from the pipeline. Let's now go to wave number 2. I can spend an entire month talking about this slide, but I will only mention that in Mexico we see a lot of continuity, the same in Argentina, but from different standpoints. In Mexico, they are reinforcing the maximalism, but in Argentina, they are reinforcing and continuing with minimalism. And I include several examples, but later on, we can talk on a one-to-one basis, because if I start talking about these bullet points, I will never end. But let me tell you what I wrote about timing. The point about Mexico is that started very, very early. Their patents were granted early in the 90s. So when in the 2000 things changed politically, when there was a penny drop, they said, oh, we made so many mistakes, but that was late. The window was closed because the national industry, the domestic industry, had disappeared. So the Ministry of Health is looking for allies to set up a domestic industry, but they cannot find any. That doesn't happen here, because I believe the way to implement TRIPS in this country more slowly, as Mariano Genoves explained yesterday, gave more room for domestic companies to adjust, and still these domestic companies have room to get a share of the market. When I see Argentina, I said Argentina lost the war, because now you have more patents, but you continue winning the small battles. Brazil, I'm not going to talk a lot about Brazil because my panel colleagues will, but there was a partial reversal with a lot of tensions. A few years later, after the maximalism in 96, when they introduced this system of prior approval, they changed other systems that you all know, until they started using between inverted commas to give compulsory licenses. I believe this relates quite significantly to the problems that the new pipeline patent system had, and the effect it had on the health system. The timing was possible because the decision to change direction came 2 or 3 years after the initial decision. In Mexico, it took some 10 years. The other thing is that the Ministry of Health, in my opinion, realized that these reforms are not enough. They are not enough, And that's why Brazil has this industrial policy in the pharmaceutical field. Yuri was mentioning about the need to have an industrial policy in the pharmaceutical company. Brazil is doing some efforts that I do not see in other Latin American countries. This is a policy that focuses on pharmaceutical industry. For instance, 5 more minutes, okay. The second project, empirical analysis. I'm not going to take long. How to respond to secondary patents. The problem here is that patents, the accumulation of secondary patents can extend the exclusivity periods. Everybody knows that. The critics call it evergreen. The ones for call it a good thing. If we take Carlos Correa and we took off the trivial adjective, all the adjective he uses, the definition is exactly the same to what the industry calls pipeline patent management. We are going to get as many patents as we can to extend our exclusivity period. You can respond at the end with litigation at the end of term, but the judges correct the Patent Office's earlier errors. This brings a public good problem, because if I make your patent invalid and I lose, all the costs are on me. If I win, it is public domain. What can we do? This is where the state should lead and set an example, because we were talking about Hatch-Waxman, but not many people talk about Hatch-Waxman. It provides an incentive. If you challenge a patent and it is invalid and you win, you receive a 6-month period of exclusivity. This is it's like a bounty. That is what we say in English. The other possibility is ex ante, that is, deny secondary patents at examination stage. Why? Because having so many patents increases the uncertainty and makes everything more complicated. The costs are difficult to reduce. It's a mess. The easiest thing to do is to prevent this once and for all. But let me tell you something. These are functionally equivalent. These are two strategies to reach the same goal: minimize the effects of secondary patents on exclusivity rights. In developing countries, for reasons we may talk about later, there's a bias to ex ante, but it is acceptable in TRIPS. It is promoted everywhere. WHO, no, Korea, UNAIDS, the Intellectual Property Rights Commission, etc. Everybody's saying, okay, but we don't really know what they are doing, because we don't know the effects. When I think about patent preemptive approaches, I'm talking about things that relate to the patent law, such as responsibility for pharmaceutical patent examination, and to have some system to pre-grant opposition that should be open, easy to use, very formal. What do I do? The method is similar to what I described before with the FDA patents. We have the PCT applications. that are submitted through the PCT 2000 to 2002. We code them primary or secondary. It's difficult to do that. We find national phase versions where they exist. We search for outcomes. We review prosecution histories because I want to know how many were rejected, how many were granted, but I also want to know, if rejected, what was the role played at section 3D. It's really difficult in a system like this with pipelines because everything is going into the same pipeline, and it's difficult to break it down. We want to check differences in patent systems and see if they generate differences in patenting outcomes. So in a very basic language, I'm asking, do flexibilities matter after 20 years of discussion? And the results, well, we have to see them. If we invite me in 6 or 8 months, I will tell you about the results. But so far, we are just trying to see. I'm not going to use any more time. I'm going to finish here. These 5 bullet points are not necessary. Thank you very much.